Thank you for tuning in again to an episode of Quint Business Academy, where investors, business owners look for tax strategies, wealth strategies, and asset protection plans. Today, we're going to talk about a very important topic, which is 1031 exchanges. We have this very special guest today. His name is Greg Burns. He has over 15 years of experience doing 1031 exchanges, and he is the Senior Vice President of IPX 1031. Thank you so much, Greg, for being here with us. It's such a pleasure to have you here to answer all of our questions today.
Well, it's my pleasure. Thanks for having me.
Yeah, basically, I just wanted to talk about the 5 biggest misconceptions about 1031 exchange, and I think you would be the perfect person to help us out understand these topics right here.
I better be.
Yeah. So basically, the first misconception that I wrote down, and for you to help us understand, is in order to complete a 1031 tax-deferred exchange, a taxpayer has to find someone to swap property with.
Yeah, that's a common misconception. I think it's because they call them exchanges, so you think that you're kind of exchanging properties with another party. The reality of it is, when exchanges first started in the 1920s, people would actually trade properties with each other. And then kind of over the years, things evolved. And then there was a famous case that happened in 1970 where a guy by the name of John Starker sold off some timberland and exchanged it for some other commercial real estate a couple of years later. Ultimately, the IRS took him to court, and it was upheld to be a valid exchange. It's a famous case, the Starker case, probably one of the most famous exchange cases that exist. So the IRS, 1991, came down with some definitive guidelines, so people didn't have to rely upon case law anymore, that allowed people to take advantage of these 1031 exchanges and allow them not worry about, scrutinizing from the government. They were covered under the safe harbor, and they can now sell their property off to a third party, buy their property from a third party, and they never have to worry about linking the parties together. It's just a traditional sale and traditional purchase.
Yeah, I think this is really important for people to understand, because they think it's just a swap between properties, and like you just explained, it's so much more than that. The second misconception I wanted to touch base on is when a taxpayer is seeking to exchange property, has to buy the exact same type of property he is selling in order for it to be considered a like-kind exchange.
Yeah, the like-kind rule is probably the biggest misunderstanding with respect to exchanges, because people think, well, if I own a single-family residence, if I want to do an exchange, I've got to buy another single-family residence because that's like-kind. The reality of it is that under the code with respect to real estate, it's really broad, the like-kind rules. You can sell residential, buy commercial. You can sell industrial, buy residential. You can even sell vacant land and buy improved property. So it really doesn't matter what the asset class of the property is. As long as you're selling property you've held for investment and you're buying property that you intend to hold for investment or business use purposes, it'll qualify.
Now, the third misconception I wanted to touch base on is taxpayers must complete the 1031 exchange in one completely simultaneous transaction.
Yeah, so there are lots of different types of exchanges that exist. There is a simultaneous exchange where properties can close concurrently with each other. But the most common type of exchange that we encounter is what they call a delayed exchange, where there's a delay in time from when the property sells to when they purchase the new property. And there's some time restrictions that they have to comply with. So typically, when your property sells, under the delayed exchange rules, you've got 45 days to identify a property that you'd like to purchase, and then you have a total of 180 days to get that transaction closed. So that's the typical, most common type of exchange. There's also a reverse exchange out there where you go out and buy the property that you want before you sell the property that you have. There's improvement exchanges where you sell your property, buy new property, and use leftover remaining exchange funds to make improvements to the property. So really, there's lots of different types of exchanges that exist, and it's probably one of them that can meet your client's goals in the event that they want to do an exchange.
Thank you so much for clearing that out. The fourth misconception that I wrote down is taxpayers must use all the proceeds from the sale of the relinquished property to purchase replacement property.
Yeah, so there's some basic rules with respect to exchanges as far as the reinvestment rules. The first rule says buy a property that's equal or greater in value to the net sales price of the property that you sold. Now, a lot of times when people hear the word net sales price, they're not really sure what that means. But that's net of escrow fees, title insurance fees, real estate commissions. It's not net of your loan. So you got to be sure that, essentially that, you replace your loan. So the second rule is you must use all of the proceeds from the sale of the property to purchase the new property. And the last and final rule is you've got to acquire equal or greater debt. Now, there is an exception to that last rule, and that is that in the event that you want to offset the debt with cash, you can do so. So if you sell a property and you've got some debt on it, you go buy a new property and you decide, I don't want to have any debt on it. I'm going to buy it. It's equal or greater in value to the property that I sold. I've reinvested all of my proceeds, but I just don't want to get a new loan. You can offset that debt with cash and purchase the property. The IRS doesn't have any issue with you infusing additional money into the real estate market.
The fifth and biggest misconception, I think, is I don't need a qualified intermediary. I can simply have my attorney or accountant hold the sale proceeds until the replacement property is purchased.
Yeah, so one of the things under the Treasury, under Section 1031, it says the client can never be in constructive receipt of the funds. So the client can't be in control of the money. So you've got to get some kind of a qualified intermediary involved. Some people refer to us as an accommodator or facilitator to facilitate the transaction. People say, well, why can't I have my accountant use it, or why can't I have my attorney, be my, qualified intermediary? The IRS specifically carves out anybody who's considered an agent of the exchanger. So if you are anyone that's worked for the client in the last 2 years, you're basically excluded from, acting as a qualified intermediary. So you need to get a qualified intermediary involved that's out there that really knows what they're doing and can protect the integrity of your exchange.
Thank you so much, Greg, for having talked to us about the biggest misconceptions on 1031 exchange. I know we have a lot more questions about 1031 exchange, and we can touch base on that. But thank you. This is part one of this session, and I welcome all of our audience to stay tuned for next week for you to hear all the biggest questions that you have sent to us to ask Greg about 1031 exchange.